going to be a review of some of the significant opinions of the last term of court, something that's become an annual event here at the law school. And I will let you know now that in a couple of weeks we'll be having a preview of the upcoming term of court. It's always much easier to talk about a case after it's been handed down, but nevertheless, we will try to highlight some of the significant cases of the new term and identify them for you so you can keep your eye out about them as they come down. And if, to the extent people want to prognosticate about outcomes, you can then hold us to those prognostications later in the semester. That's on October 9th, I believe in this same room, but at the noon hour on October 9th. So today we're going to talk about, as I say, some of the significant opinions of last term. One we will not be talking about is the D.C. guns case. We thought that deserved a lunch hour or other event on its own, given its significance. And we're working on getting one of the lawyers for Mr. Heller, who was the plaintiff in that case, to come to the law school, and he's agreed to do it. We're just working on the schedule. So at some point in the near future, I will announce through Duke Law Daily and other means when we're going to be talking about the D.C. guns case. Today we will talk about three and maybe an additional one or two significant decisions, and we have to discuss those three of your faculty members, Kurt Bradley, Guy Charles, and Ernie Young. We're going to be talking about the Petition decision having to do with the habeas corpus right, Crawford versus Marion County Election Board, the case involving voter identification requirements, as well as perhaps one or two other of the election-related decisions from last year. And then the Medellin case, Medellin versus Texas, which involves more than one issue, a complicated transaction involving the role of international law, the power of the president to direct states to meet United States obligations, and the like. And Medellin will come last. So we're just going to go in the order in which folks are seated at the table, and hope to have ample time at the end for your questions, either about these decisions or about something that we haven't covered that you're interested in. So, Professor Bradley, let's get it started with you.
Great. Thanks, Chris. Thanks, everybody, for coming. So the case I'm going to talk about and briefly describe, probably not say a lot about my own views of it, but maybe that'll come up in the questions, is Boumediene versus Bush. This is the latest Supreme Court case concerning the war on terrorism, and specifically it concerns the detention by the U.S. military of terrorist suspects at the Guantanamo Bay Naval Base in Cuba. There's some complications about the U.S. arrangement there, but ultimately we have a treaty with Cuba that effectively actually says that the U.S. has complete jurisdiction and control over this area where the base is, but it actually says Cuba also retains ultimate sovereignty. But through some negotiations in the 30s, it's clear that Cuba cannot ask the United States to leave the base. So the United States has an indefinite arrangement, and if it decides to close the base, it could, but Cuba cannot insist as a legal matter that the U.S. ever leave the base. Probably a lot of you know that after the September 11th attacks and then the resulting conflict in Afghanistan and also a global effort to seek out and apprehend terrorists, the U.S. government started detaining some of the people it apprehended at the Guantanamo Naval Base, and then started constructing detention facilities there. It's always been a mix of individuals, some people who were literally caught up on the battlefield in Afghanistan, members of the Taliban military, some other people who are alleged to be part of the Taliban but were caught in other sorts of ways in Afghanistan or in Pakistan, and then others who are just alleged to be members of al-Qaeda who are caught all over the world in cells or in other places, and our intelligence suggests that they're connected, and then they're apprehended in various kinds of ways. And some of those people have been brought to Guantanamo, as I mentioned. It's clear from legal documents that we at least now have from the government that one of the goals or thoughts early on after 9/11 was that Guantanamo would be a very good place for detention because the U.S. has extensive ability to keep security there, and it's very close to the United States, but the prediction was that U.S. courts would be unlikely to exercise any judicial review, or at least much, over the base. It turns out that wasn't the case, but that was what was thought. At times there have been over 600 people at any one time at the base, although it's clear that in the last couple of years the government has tried to reduce that population by sending people to their countries of citizenship if the countries will take them, sometimes with continued detention, but sometimes they're allowed to go free. And we're down to around, I think, about 250 detainees at Guantanamo right now. These are people being held by the government, obviously against their will. They don't want to be held. And if one is being held in the United States territory, at least, and you think that there's some legal problem with the government holding you, the traditional means to try to get this tested out would be to file something that's called a petition for a writ of habeas corpus. And it's really a petition that, where the court directs the government to explain why, under the law, it has the power to keep you in detention. So there's certainly been efforts to do that on behalf of the Guantanamo detainees. The modern Supreme Court's case law on just this general idea of habeas corpus, I won't say much about it, but it's clear the Supreme Court assumes that there is some constitutional right to get access to the federal courts, at least for some class of litigants, to test out the power of the government to detain them. And part of that, at least, is coming from a provision in the Constitution. There's a provision that says that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. And at least the modern Supreme Court has read into that the idea that the Constitution seems to assume that at least people in the United States have a right of habeas corpus, a right to petition for review of their detention, unless Congress has used this power to suspend it in time of rebellion or invasion. They've said that in some immigration cases, for example. And so the question in Boumediene is whether this right that the Constitution seems to recognize to petition for review of your detention applies outside of the United States. The Guantanamo base is not part of U.S. territory. It is in Cuba, although under this kind of strange arrangement that I've described under the lease. And the government would have had some reasons as a matter of precedent to think that the answer was no, that the constitutional right of habeas does not extend outside the U.S. In particular, there was a case from the World War II era. It's a case called Johnson against Eisen Trager, case where right at the end of World War II, a group of Germans were caught in China. Germany had just surrendered, and under the laws of war, you're not supposed to keep fighting or aiding the enemy if your country has surrendered, and they did. They tried to provide intelligence to the Japanese, who were still fighting against the United States. And they were apprehended by the U.S. military in China and then tried by a military trial for violating the laws of war, and then actually housed in a prison in the occupied Germany at the end of the war. And they tried, there were 21 German nationals, they tried to get review in U.S. courts. And there's a big question about how to read the Supreme Court's opinion. This is a 1950 decision, but one could read the decision as saying that the constitutional right of habeas corpus does not apply outside the United States to non-U.S. citizens who are being held as enemy detainees. And there's some language that is that broad. And if that were true, you could apply that to Guantanamo if you're the government and say these individuals being held as the enemy, Taliban and al-Qaeda individuals outside the United States, and they've never in fact been to the United States, and that the constitutional right just doesn't extend there, based on Eisen Trager. Having said that, before Boumediene, which was just decided this last June, there was some foreshadowing, to maybe even put it mildly, by the Supreme Court that it might have had different views about this question than the court did in the World War II era. There was a case called Rozzell versus Bush, which was one of the first cases in the War on Terror decided in 2004, where the detainees of Guantanamo first tried to get habeas review. It turns out that Congress has always provided some statute that provides some habeas relief in addition to the constitutional provision. And the detainees tried to sue under the statute, and a 6-3 majority of the court said they did have the ability to use that statute to get some judicial review of their detention. And the court distinguished this Eisen Trager case, noting, among other things, that it was clear in that case that these really were the enemy, but there were some questions about who the enemy is in the war on terrorism. In addition, there had been a military trial in Eisen Trager, but the people at Guantanamo, essentially almost all of them, have not been subjected to any trial process. Very importantly, if you're watching and counting votes in this Rozzell case, you would have noted that there was a concurrence by Justice Kennedy, who everybody recognizes today as a key swing vote on the court, a key vote on close cases. He wrote specially to say that in his view, Guantanamo, given the absolute control the U.S. exercises there, he said, was in every practical respect a United States territory. So now this was just a statutory case. It was technically the case was how far does the congressional statute run? It doesn't actually address how far the constitutional right runs. But certainly the idea that this is really part of U.S. territory in a practical sense, you can imagine applying that to the constitutional analysis if you were looking ahead. Well, in the meantime, after this Rozzell case, Congress actually tries to cut back on what the court has done. And so they actually pass an act in 2005 that attempts, it looks like, to strip any statutory right of habeas corpus at Guantanamo. The Supreme Court interprets that statute very narrowly and says that it doesn't apply to any pending cases. And it turns out almost all the cases that would have mattered are already pending by the time that has happened. And so effectively the Supreme Court, and it's a case called Hamdan versus Rumsfeld, reads what Congress is trying to do as not really affecting the landscape and therefore allowing still all of these cases to continue in the federal courts. Congress responded again in 2006, something called the Military Commissions Act, and basically the statute says we really, really mean to strip jurisdiction out of the federal courts in these Guantanamo cases. And so it's so clear now in the statute that it says pending cases right there in the statute, so there's really no question that Congress is trying to cut off this Rozzell decision and stop the judicial review on habeas corpus. Now importantly, and there's a bunch of complications here I'm not going to summarize, but Congress doesn't actually try to stop all review of Guantanamo. That would have been very dramatic. What it does is it tries to provide an alternative route of review, and it basically says that the D.C. Circuit Court of Appeals should have the only ability to directly review what's going on at Guantanamo, and that the individuals who are being held as the enemy in Guantanamo should be limited to appealing their these military determinations that they really are the enemy directly to the D.C. Circuit, and that court can resolve questions about whether the process is fair at Guantanamo and maybe even some constitutional questions about the detention, but only in that court, and it shouldn't go through the usual route of just filing a petition for habeas corpus. That's what it looks like Congress tried to do in the Military Commissions Act. Well, that tees up Boumediene. These are, again, people at Guantanamo being represented, and they want to still get the right to petition for a regular habeas corpus in the district court. The two questions in the case, one is, do they in fact have a constitutional right that would exist even without a statute to petition for review, given the Eisen Trager case in particular? And second, assuming they do have a constitutional right, and by the way, it looks like Congress hasn't tried to use its rebellion and invasion power to suspend that right, has Congress provided an adequate alternative to that right through the D.C. Circuit review provisions that it set up? Those are really the two questions in the case. The court splits quite sharply on both of the questions. It's 5-4 decision on these two questions, and maybe we should have predicted this. The author of the majority opinion is now Justice Kennedy, the key swing vote, somebody who had already signaled some of his views in Rozzell, and he joins the majority to hold that there is a constitutional right of habeas review that extends to the people at Guantanamo, and second, that the D.C. Circuit review provisions that Congress has set up are not adequate to substitute for that right. Two very lengthy dissents, one by Chief Justice Roberts, one by Justice Scalia. I'll just say a bit about those two dissents in a minute, but I won't try to summarize them. So what's the basic reasoning of the majority? First is to there being a constitutional right. The court says, we understand the government's argument, which is that Cuba really does have sovereignty in a legal sense over the base, which is true, but the court says we want to look more functionally or practically to who has real control over the base, and at least consider that as one of our factors. And in that sense, the U.S. has what they call de facto sovereignty. They have this absolute ability to regulate and control what happens there with really no ability by Cuba to change that. And they say in every practical sense, Guantanamo is not abroad, it is within the constant jurisdiction of the United States. Now that sounds like what Justice Kennedy had said in Rozzell, and now he's saying it for the majority on this issue. The court has to go through a lot of old decisions on the reach of the Constitution abroad, and what it draws from those decisions is no bright line about the Constitution's reach abroad, but rather cases that it says turn on practical and functional considerations of what problems would be posed if you try to apply certain rights abroad. In their view, there would not be significant practical problems in extending at least this judicial review right just to Guantanamo. The court also expressed grave concern that if it came out otherwise, in this day and age, that it would be allowing the government, in effect, to choose when it wanted to shut off the Constitution or not, and just easily evade the restraints that it would otherwise be subject to by setting up these enclaves that it really did have control over, but were technically not part of the United States. So it said the government should, quote, not have the power to switch the Constitution on or off at will, which it perceived was sort of going on in this case. On the second major holding, which is that these alternative review mechanisms in the D.C. Circuit were not adequate, I won't go through most of that, but but it ends up being important because one of the things the court says is that on its face, it wasn't clear, for example, that the D.C. Circuit could actually order someone's release from Guantanamo if they found that, in fact, the detention was illegal. And the court said that is really sort of the core of having the habeas right, is to go to a court and if you're being held illegally, to actually be ordered release. I'll just mention in 1 second why that's significant. It comes out of sort of one of the dissents. So two dissents. Scalia's dissent very much focused on this issue of whether the Constitution should apply abroad, and he says it should not. Chief Justice Roberts focused on whether the D.C. Circuit review provisions are adequate. He thinks that one could construe them in a way that would be adequate. And more importantly, Roberts' argument is this is the first time any court has actually looked into it. It turns out if you look at the posture of the case, the lower courts had not even addressed whether the D.C. Circuit provisions were adequate, nor had they addressed the scope of what you could get in the D.C. Circuit yet. The D.C. Circuit was just working on those issues at the time. And the reason why that's particularly interesting is that a week after this decision, the D.C. Circuit finally decides one of those questions and says, yes, we can order the release of people at Guantanamo. They read these provisions that the majority was worried about not giving a release right, in fact, to give the very thing that the court thought was necessary. And if Roberts, I'm sure, had known that that was coming, he would have pointed out that was an argument for letting a little bit more process occur in the lower courts before the court decided these constitutional questions, which is actually the normal practice of the Supreme Court, is not to reach out for constitutional questions that haven't been decided below, particularly if there's some opportunity to construe the statutes in a way that might save them their constitutionality. Scalia's dissent, if you've read it, is quite striking. So Roberts' dissent, very lawyerly, very much focused on process and conserving the court's resources for when they're needed. Scalia's a very different kind of dissent, very kind of dramatic and inflammatory. Starts out by saying the majority's decision, quote, will almost certainly cause more Americans to be killed. And it goes from there. And that made some headlines when it was announced. So we can talk more about those. I'm about out of time. A couple of observations about the case. One is, my own view is it's not a very surprising holding that the Constitution has some applicability to Guantanamo. The court had already kind of signaled that. If the government was surprised, they probably shouldn't have been, given Kennedy's vote. It is a bit surprising, in my view, and we can talk about this, that the court did sort of almost bend over backwards to find that the statute's unconstitutional. There were some ways to read the D.C. Circuit review provisions quite broadly. The D.C. Circuit's actually now doing that, and they haven't even been addressed in the lower courts. It is odd to do that at any time, to sort of reach out and do that. It's particularly odd during a national security situation or war to reach out and not only slap down the administration, but to actually slap down a recent statute by Congress. We can talk about that. The third thing I want to note is that there are a lot of issues that the Boumediene case does not resolve. In fact, most of the really important substantive questions, who is the enemy in the war on terrorism, really not resolved still. What's the amount of process that they need to have, not really resolved. How far does the Constitution go beyond the unique facts of Guantanamo? Nobody has any idea. How long can the detainees be held? Again, not resolved by the case. So a lot of key questions left open by the case that the lower courts will now have to start to grapple with in these habeas cases. And my last observation, just to have a little bit of a bite to my remarks, is Boumediene, whether you like it, dislike it, very close decision, is, in my view, a case that illustrates a court with great confidence in the abilities of the judiciary. So during a time in which there are very difficult policy questions about how to treat detainees and about who the enemy is and questions that obviously the political branches are grappling with, the court has announced a decision that both knocks down the collective wisdom of both the President and the Congress very recently, but also sends to the lower court a tremendous number of very difficult questions, and at least in the first instance is asking the courts with very little standards or guidance to try to start giving us answers about how we conduct this conflict. And that certainly suggests at least a confidence that the courts can make these difficult evaluations.
Well, the two cases that I'm going to talk about today, no one is dying in them, and no one can accuse anyone of killing anyone except for the fact that the fate of the republic is at stake. So I'll talk a little bit more about Crawford versus Marion County, which is the Indiana voter ID case, and then say a few words on FEC versus Davis, or Davis versus FEC, which is the Millionaires Amendment, the aptly named Millionaires Amendment case. All right, so on Crawford, this is Stevens' opinion announcing the judgment of the court. Plurality, authored by Stevens, joined by Roberts and Kennedy, with a concurring opinion by Scalia, where he was joined by Thomas and Alito, and dissent by Souter and Breyer, with Ginsburg joining and Souter, I believe. So if, at the outset, there, you've got a very interesting lineup, and I'll say a little bit more about that towards the end. But this is an Indiana statute requiring that voters at the polls present a government-issued voter ID. And the state will offer the photo ID for free. And if you don't have a photo ID, you can cast a provisional ballot and either come back later on and bring your photo ID, or provide an affidavit that says that you are within 10 days after the election, that says that you are who you say you are. The plaintiff filed suit and challenged the statute. It was a facial challenge, so they weren't challenging particular applications of the statute. They were challenging the statute on its face, arguing that the statute burdened the right to vote because it will franchise a number of individuals without a voter ID. So the way I think to think about this, and the way the court thought about it, is to what extent is requiring a photo ID similar to a poll tax, which the court long ago invalidated. The district court rejected the claim. The Seventh Circuit and a very interesting Posner opinion, affirmed, and then the Supreme Court also affirmed. So Stevens says, look, the question here is how do you measure the burdens against the interests that the state is trying to uphold? The state says the reason why we need a voter ID is that we're worried about voter fraud. We're worried about the confidence of the voters in the system, and we're also trying to make up for the fact that we have an election process that is deficient at various stages, that we have individuals who are registered or whose names are on the rolls that we really aren't sure are alive, are still living in the state, are qualified to vote. And so we're trying to come up with mechanisms of assuring, because of our deficiencies, of assuring that we can adequately protect the integrity of the process. Fundamentally, this case comes down to how do you gauge a case where the government can't present a single instance of voter fraud, but the plaintiffs can't present a single individual that are being denied to vote who has been being denied to vote as a consequence of the voter ID, right? So essentially, you have a case that you've got to make a balancing test, but there appears to be very little to put in the balance. And I guess in some instances, one way to think about this is if you have an empty balance, the government wins. So Stevens says the burden here is minimal. Repeating some things that Posner said in his opinion, look, you need a government ID to do everything. You know, if you want to show up to the classes of the esteemed individuals on my right and left, right, they will ask you for a photo ID. Are you entitled to be here? You want to come into the law school, you need a photo ID. You want to go into the airport, right? So Stevens says, you know, an ID at this stage of life is a fundamental requirement for going about living one's daily life. And so he recognizes that the burden, or says that the burden on the individual is minimal, but the interests of the government are strong. The interests are strong because the government cares about fraud. And this is one of these interesting things about fraud, right? Whenever you raise fraud as an issue, I mean, how can one deny that trying to prevent fraud is a compelling governmental interest, right? At any stage you're trying to prevent fraud in an election process, sure, that sounds great. At any stage at which you're trying to improve voter confidence, that's extremely important. We want voters to confidently go to the polls. We want them to confidently believe that their votes are going to be counted. We want them confidently to believe that the individuals that we said received the most amount of votes are, in fact, the ones who received the most amount of votes, right? So all of those things, here the court says we defer, in contrast, say, to matters of national security, where the court is is fairly sure how to think about these issues. But when it comes to matters of election administration, I think the court perhaps rightly understands that elected officials may know better how to think about matters of election administration in contrast to matters of national security, which the court confidently weighs in. So fundamentally, the court rejects the view that, or the majority rejects the view that voter IDs are similar to poll taxes. Interestingly, and here let me point out some differences among the three principal actors here, Scalia, Stevens, and Souter. Interestingly, Stevens says, look, if the government required you to pay for your ID, then that would be similar to a poll tax, and I would find that unconstitutional. Although, in order to get an ID in Indiana, you need a primary document, and one primary document is a birth certificate, which you're required to pay for somewhere in the neighborhood of $3 to $12. And then Stevens says that is true, but generally just about everybody can afford to pay for the primary document. So at one level, in my mind, as I read this and I think about this, okay, so if they asked you to pay for the ID but provided you the birth certificate for free, that would be unconstitutional. But since they're giving you the ID for free, but then they require you to pay for the birth certificate, which you need, in fact, to get the voter ID, that is not unconstitutional because you could pay $3 to $12 for a birth certificate, but if you're required to do that for a voter ID, that's a constitutional problem. I get it. I can teach that. So it's an interesting question for Stevens. Scalia says, I want to concur here because the whole reason why Stevens is writing this opinion is because he really wants to change the framework, the doctrinal framework, and the balancing test. And my point here is that is Scalia, is to clarify that the balancing test, or that the test to be used here is an extremely high one, where the government has a compelling interest and the burden is minimal, just because it may impact some individuals disproportionately, right? So if you're poor, or if you can't get to the DMV, Department of Motor Vehicles, or if you're older, right? So there's some discussion in the opinion about elderly voters who have difficulty getting a birth certificate because either they weren't born in Indiana and that makes it harder to get a birth certificate, or the record-keeping processes disproportionately impact them. So we understand that this disproportionately impacts some individuals, but for Scalia, that is not enough to raise a constitutional question because everyone is being burdened. It's just a question of some individuals are burdened more than others simply because of their social location, right? And he wanted to point that out. By contrast, Souter finds disproportionate burdens of constitutional moment, and that's just the justification for his dissent. So fundamentally, on the voter ID question, what matters is, as Stevens makes clear, and it's not clear, for example, how a swing person like Kennedy would think about this, but as Stevens makes clear, given the fact that the government provided this for free, and given the fact that in this day and age one really needs a voter ID, then that is not a constitutional problem. Let me just make one observation before I leave this, and then just briefly describe FEC versus Davis. And the observation is this: what's interesting about the voter ID debate, obviously, is its partisan division, right? There is fairly good evidence that what motivated the enactment of this debate is the fact that it's going to have a disproportionate impact on certain types of voters who vote in a particular way, right? So the question then is, how does one think about that? And Stevens, in fact, addresses this and says, if this statute were motivated simply because of partisan identity, that would be a constitutional problem that I would find troubling. And quite frankly, when you look at Kennedy's jurisprudence in this area, where especially in the redistricting cases, or more importantly in the partisan gerrymandering cases, Kennedy is very concerned that where individuals are targeted because of their partisan identity, right? You pass a voter ID law because you know it's going to impact Republicans or Democrats, Republicans more than Democrats or Democrats more than Republicans. For Kennedy and for Stevens, that's a constitutional problem under the First Amendment. So one way that one might think about these issues in the future might be to emphasize and to think about the partisan consideration as opposed to the 14th Amendment sounding equality consideration. You know what? I'll stop here and leave FEC versus Davis for another time.
Okay, well, the fate of the Republic is at stake in the Medellin case, but it's the Republic of Texas. Medellin is a wonderful collision of international courts, the president, and the states. And I think in this case we can discern a little bit about where the Roberts Court is going on three key issues. One is, what's the relationship between international law and international courts and the domestic legal system? The second is, what's the breadth of executive power? And then the third is, we may be able to tell a little bit, but less, I think, about the extent to which the Roberts Court is going to continue the Rehnquist Court's fascination with and concern for federalism. Medellin is the most gloriously complicated case I've seen in a long time. I am really sad to see it go. It went on forever. It got more and more tangled, and it was a beautiful thing while it lasted. Jose Ernesto Medellin is a Mexican national, but he had lived in the United States since the age of 3. He was tried and convicted in Texas state court, brutally raping and murdering 2 teenage girls in Houston as part of a gang initiation. His confession admitted that he strangled one of the girls with her shoelace to prevent her from identifying him after the rape. The problem in the case arises from the fact that the Houston police did not notify Medellin that he had a right to speak with the Mexican consulate under a treaty called the Vienna Convention on Consular Relations, the VCCR. There's no question as to his guilt, but it's possible that if he'd been able to speak to the consulate, they might have helped him out at the sentencing phase of his trial and maybe enabled him to put on a better defense at that stage and avoid the death penalty. The problem for Medellin in raising that argument as a defense to his prosecution is that he didn't. He didn't make the argument in state court. And that means, under very complicated rules that I'm happy to teach you over 2 or 3 weeks in federal courts, that he procedurally defaulted his claim. That means he couldn't raise it in any later proceedings, either in state court or on federal habeas corpus review. However, Medellin's claim was also encompassed by a broader suit filed by Mexico itself against the United States in the International Court of Justice, which raised VCCR violations with respect to 53 different Mexican nationals who are on death row in various jurisdictions around the United States. All of them claimed that we had failed to notify their nationals of the right to speak to the consulate. And the case is brought pursuant to another treaty called the Optional Protocol to the VCCR, under which a subset, certainly not all the states that have agreed to the VCCR obligation, but a subset of those states have agreed to have disputes under the treaty adjudicated in the International Court of Justice. At the time of this decision, the United States was one of those states, as was Mexico. Mexico won that suit in the International Court of Justice, and in a decision called Avena, the International Court of Justice said not only had the rights of these nationals been violated under the treaty, but also that the state courts, the domestic courts in the United States were not entitled to apply this doctrine of procedural default. So whereas an ordinary litigant would have waived the claim by not raising it at the proper time, this treaty right was special according to the International Court of Justice, and you had to let them raise it at any time. So the first time that Medellin's case comes to the U.S. Supreme Court, it looks like the court is going to have to decide what to do about an International Court of Justice decision interpreting a treaty and whether that trumps a state rule of procedure like the procedural default rule. But that's when the president jumps in. The president issues a memorandum, not an order, but a memorandum addressed to his attorney general for reasons that remain somewhat mysterious to me. And it simply says, the United States will discharge its international obligations under the Avena case by having state courts give effect to the decision in accordance with general principles of comity. Now, you might think then there's a long explanation. You'd be wrong. That's all the memorandum says. So at that point, the U.S. Supremes ditch the case, I think, with a big sigh of relief, because they think, well, hey, maybe Texas will give this guy a break. So it goes back to Texas State Court. In the interim, though, you should also know that the United States Supreme Court decides another case under the VCCR called Sanchez Yamas. And in that case, which does not involve any parties to the Avena judgment, but does involve the same issue, which is, do procedural default rules apply to these treaty claims? And the United States Supreme Court says it does. And they look at the ICJ's decision in Avena and they say, sorry, the International Court of Justice got it wrong. They misinterpreted the treaty. Procedural default applies. Now, Medellin's back in state court in Austin. He files a new state habeas petition in the Texas Court of Criminal Appeals, which is the Texas Supreme Court for criminal matters. The Texas court ultimately says, no, you don't get any slack just because you've got an International Court of Justice ruling and a presidential memorandum. They say that the Avena decision doesn't bind them. We're Texas after all. And the president's memorandum is unconstitutional, even though he's our former governor and we still love him. That ruling then gets appealed to the U.S. Supreme Court. And in the Supreme Court, there are two different ways that Medellin could win. He could persuade the court that the ICJ's decision in Avena simply is binding on the Texas Supreme Court and the U.S. federal courts and everybody else. Or he could persuade them that whether or not the ICJ's decision binds of its own force, the president has the authority to make it binding through a memorandum. Right? And the court says no on both these arguments. And we'll talk a little bit more about why in a minute. The denouement played out last month. There were efforts to get a statute passed in Congress that would make the ICJ's judgment binding or reopen these cases. Not surprisingly, Congress had better things to do in an election year than go to great efforts to help a convicted murderer. Not politically popular to do, right? The Texas legislature couldn't do anything because it doesn't even meet this year. It meets every other year. So Medellin then goes back to the Texas Court of Criminal Appeals, says, can you cut me a break? Can you give me a stay until these legislative efforts maybe can bear fruit? The Texas Court of Criminal Appeals says no. Nobody dies of surprise. The U.S. Supremes are also unwilling to intervene at this time, and so Medellin was executed on August 5th, 2008, which unfortunately means this case is finally over. Now, does that mean that we violated international law by not complying with the Avena judgment? And everything you read in the press will tell you so. It's not quite that clear. What the ICJ ordered Texas to do was to review whether Medellin was actually prejudiced by not being able to speak to the consulate. And it turns out that in some of the earlier decisions in the case, as an alternative ground, some Texas courts had ruled that there was in fact no prejudice. And so Texas took the position at the very end of the game that, you know, we actually did what the ICJ asked us to do, and we found that there was no prejudice. Now, Medellin and his lawyers argued that they applied the wrong standard. My guess is the ICJ would probably agree with that, but my guess is also that that agreement would be motivated, at least in part, by dissatisfaction with any outcome here that doesn't avoid the death penalty. Texas has committed itself for all the other Mexican nationals that remain on Texas death row, and there are a few, that are subject to the Avena judgment, that they will provide the review and reconsideration that the ICJ has ordered. So having established their point, they're willing to make nice. So what can we tell about these foundational issues from Medellin? Medellin is being pitched as a case about treaties. And a big question with any treaty is it self-executing? And that means, does it have legal binding effect within the domestic legal system in the absence of further action by Congress? And there's no doubt that the VCCR is self-executing in some ways. It may not be self-executing in others. There's a meta-debate about what the default rule ought to be. If the treaty's unclear about whether it's self-executing, should there be a presumption in favor of self-execution, as a lot of internationalists argue? Nationalists tend to argue there should be a presumption against self-execution. I think Medellin comes down in the middle, with no firm presumptions either way. You have to look carefully at the treaty. But it's important to understand that Medellin actually doesn't hold anything about when treaties are self-executing, because the question in Medellin is whether a judgment issued under a treaty is self-executing. You may think that's another one of your hyper-technical distinctions, Professor Young, but it actually makes a difference because the Supremacy Clause says that treaties are part of supreme federal law. It doesn't say anything about judgments rendered under treaties, and that might make a huge difference, actually. The court says that the judgment is not self-executing, that for a supranational court judgment to bind within the domestic legal system, it has to be made self-executing by an act of Congress or something like that. Or at least there has to be something in the treaty that would say judgments issued under this will be self-executing. Since there's nothing like that, the court says, we're not bound by this judgment absent further action by the political branches. So that's a pretty important point about what the impact of supranational courts' rulings will be within the domestic legal system. And the bottom line is it's up to Congress to determine what that impact will be. We're not going to decide that as a matter of first principles. There is one distressing point about the debate on self-execution in Medellin, and that is that it's almost 5-4. It's 6-3, with all the conservatives saying that the judgment is not self-executing and all but Justice Stevens of the liberals saying that it is, which is consistent with a general politicization of this point, of a general set of issues about the impact of international law within the domestic legal system, whether we should look at foreign law in constitutional cases and all sorts of questions like that. This shouldn't be a left-right issue because often the international law question will cut in different directions. There are a lot of areas where the domestic legal system is considerably to the left of the international system in most foreign courts. For instance, on the scope of free speech, especially hate speech and libel, on the right to abortion, on rights against unreasonable search and seizure. So liberals ought to be skeptical of international law in any number of consequences, and these justices ought not to be dividing so closely on political grounds. Let me talk just briefly about the presidential power question. There's a big case about presidential power. It was arguably the boldest assertion of presidential authority to just order people around with any statutory authorization from anyone in a very, very long time. And it made for strange bedfellows. I actually had both. I filed an amicus brief on behalf of Texas in this case on the presidential power question, which was joined by both John Yoo, who a lot of people think is a war criminal because of his broad view of executive power, and Erwin Chemerinsky, our recent colleague, who a lot of people think is left of Lenin. So if you put those two people together, and they both say that the president has gone too far, the president's gone too far, right? And the court actually strictly applies the Youngstown Framework, which basically holds that the president's power is a function of congressional authorization, and if Congress doesn't authorize presidential action, then he's on pretty thin ice. It explicitly says that all those non-self-executing treaties out there, the president does not have unilateral authority to make them self-executing. That's a pretty important holding. And then finally, they suggest that there is no such thing as a general foreign affairs power to issue orders to protect our diplomatic posture in the world. And that's also a pretty important holding. Let me just say a quick word about federalism. This is not, there are a lot of federalism issues explicitly in the case that the court doesn't get to, but I think you may be able to discern some hints. First of all, this is a foreign affairs case, and the tradition in foreign affairs cases, at least in the earlier part of the 20th century, was to say that the states disappear, they don't exist in foreign affairs. And this decision emphatically does not take that tone. They repeatedly suggest that there are important state functions that are being invaded here. This is appropriately sensitive. So that may be an important shift. And then the second thing that is, as a practical matter, most separation of powers questions are also federalism questions, because the easier it is to create federal action and create federal law without going through the state's representatives in Congress, if the president can act on his own, for instance, that's a much greater threat to state autonomy. So by holding the president's power in check, the court has also done something to protect the states. I'll desist.
Thank you all. So we have some time for some questions. Yes.
Going back to the treaty question that if the optional protocol, the optional protocol serve relative to the DPPR, if not as a kind of de facto, we will execute the
Well, it means that you have agreed to be bound as a matter of international law, which is not nothing, right? That's significant because many parties to the Vienna Convention on Consular Relations have not even agreed to be bound by the ICJ as a matter of international law. It also provides, in not only the optional protocol, but also the UN Charter, which has some provisions relating to ICJ judgments, for a specific enforcement procedure at the United Nations that runs through the Security Council. And in that respect, the court says, because they explicitly provided for this other remedy, then we're not going to infer a much more dramatic remedy, which would be direct enforcement. That would be contrary to their expectations. And that dovetails with a broad set of cases where the court has been unwilling to imply remedies when there are narrower and more specific remedies available under statutory schemes and various other situations.
I was just wondering, with the voter identification issue, if there was no person that had been disenfranchised, how did it meet the ripeness requirement? And like, who was the plaintiff?
All right, so what happened was that there were plaintiff organizations as well as individuals who came who came and said, look, I don't have a voter ID. Okay, so then you have a deposition. Well, why don't you have a voter ID? Can you afford a voter ID? Well, I don't think I can afford a voter ID. In fact, one individual at the deposition said, I don't think I can afford one, and I'm not sure that I really want one. So part of the question that the court is addressing is, well, given the fact that, yeah, you have some individuals who say they don't have a voter ID, but they can get one, and the burden on getting a voter ID is not very high. And so we can't say that as a matter of law that these individuals have been disenfranchised as a consequence of the voter ID law. Now, of course, Souter takes a very different view and says, look, you have at least 40,000 individuals who do not have a government-issued voter ID, and a lot of them can't get a government-issued voter ID. So there are two ways of thinking about this problem. One way is to say, do we have specific proof on the number of individuals who do not have an ID and absolutely can't get one, right? And what does that mean? How do we ascertain they can't get one? Souter's willing to say it's reasonable to assume that out of 40,000 plus individuals who don't have government-issued voter IDs, that tens of thousands of them will be disenfranchised as a consequence of this law, and that's enough under the 14th Amendment to invalidate it, and that's his disagreement with the majority. So it isn't the fact that you didn't have specific individuals who said, I don't have one, and therefore I can't vote. The question was pushed as to, well, does the fact that you in fact currently do not have one mean that you can't get one, and is that significant for 14th Amendment purposes?
You have to keep in mind that in Justice Souter's cheap New England Yankee universe, this $3 that you have to shell out for the birth certificate is a lot of money.
Also in the voter ID case, you mentioned Scalia's opinion basically saying it's okay if it has a adverse effect as long as it's equal, and even if it ends up applying socioeconomically unequally, it's okay as long as the actual straight up effect is equal. Is that right?
That's generally right. I mean, so if you remember back to your con law classes, what Scalia is saying is there is no intent to burden a class of, and you're not burdening people, you're not intentionally saying we're out to get black people, we're out to get women, we're out to get elderly people. You're passing a law of general applicability, right? And laws of general applicability will have disparate burdens. So a registration law to register to vote will have a disparate burden. And so what he's saying is we, the court, have never held that this type of disparate burden is unconstitutional.
Couldn't that same logic be used to justify like a straight up poll tax though? Couldn't you say, well, everybody has to pay $10? Sure, it affects some people more than others, but everybody's paying the same, and we're not targeting poor people. Of course we're not.
Right. I mean, and yes, and that justification could be used to to address the poll tax, that the poll tax and of itself. Now, the way that Stevens gets out of that is he says there is no relationship between a poll tax, the government purpose here, and the regulation, right? So he says, well, what is the justification for having a poll tax? Okay. Whereas he says here, the justification for having a voter ID is to combat fraud, and there is a relationship between combating fraud and the government ID. But there's no relationship between the poll tax and whatever government justification that one can put forth.
Well, thank you, and thank you, gentlemen. We're adjourned.